The eviction notice landed on the kitchen table like a grenade, and I stood there reading the words 30-day notice to quit premises, printed in aggressive red letters across the top of an official Fairfax County document. My name was on it. The address was the house I had lived in for 5 years. "You have until Friday to give us $25,000, or pack your things," my mother said, still wearing her Walmart vest from her afternoon shift. She pointed to a loan document bearing my signature. The same pressure, the same slant, the characteristic curl I had spent 31 years developing, without ever thinking someone in my own family was memorizing it for exactly this purpose. The paper claimed I had borrowed $25,000 from the Mitchell Family Trust yesterday. Yesterday, I had been at the Deloitte office from 7:30 in the morning until past 6 in the evening, sitting in a glass-walled conference room with 3 colleagues who had eaten lunch with me at my desk. Tyler slid my private Wells Fargo bank statement across the table, the one that went to a P.O. box I had set up specifically because certain members of this household had elastic boundaries around what counted as private. The statement showed $47 in savings, with several transactions highlighted in yellow marker. "Sarah, you are 29 years old," my mother said, "making $78,000 a year, and we need your contribution to keep this family house running, or you need to find somewhere else to live." She said it with the flat delivery of someone who had already moved past the emotional part to the administrative part. Tyler said he and Megan couldn't raise baby Lily on his construction salary. Kayla said she needed support for nursing school. Megan said we are all sacrificing here, and that word, sacrifice, landed with a particular weight. I walked to the living room file cabinet that the family had always mocked as my obsessive record-keeping habit, and retrieved the thick pink folder labeled Household Expenses 20202024. It landed on the kitchen table with a sound heavier than paper should make. Tyler's confident expression showed its first crack. I read from it like a findings presentation to senior partners at Deloitte, because that is exactly what this was. March 2200. For an emergency mortgage payment when both parents lost their jobs. June 22, 2100 for my mother's gallbladder surgery. October 22, 6800 loan to Kayla for a car, signed promissory note, never repaid. February 22, 111,500 invested in Tyler's home improvement business, which folded in 4 months with 0 returned. August 22,000, 7,300 for Kayla's nursing school tuition. The roof, the HVAC, Dad's diabetes medication, Tyler and Megan's wedding venue upgrade. The receipts kept coming, each one placed on the table face up. The total, $65,740. 5 years, $0 repaid. "We just thought you would keep paying," my mother said. And it came out without the framing she had intended for it. "You thought wrong," I said. Saturday morning at 6, pounding on my bedroom door. When I opened it, my mother stood holding 2 garbage bags and a cardboard box containing 5 years of my life compressed into the volume of a large camping cooler. She handed me a certified mail receipt dated 3 weeks ago. My name, this address, a Fairfax County stamp. The mail had been intercepted. This had been planned for weeks, with a level of operational coordination I had not previously associated with my family, though, in retrospect, I should have recognized that they had always been capable of sustained, organized effort when the goal was financial extraction. I drove to an extended stay America on Route 50, where $89 a night bought a room smelling of industrial cleaner and accumulated sadness. I sat on the hard bed and opened the forwarded mail they had sent with me, mostly junk, mostly nothing, until a certified envelope from the Internal Revenue Service stopped my blood cold. Notice of federal tax lien. Amount owed, $32,400. Property at 1247 Maple Street, Fairfax, Virginia. Recorded November 10, 2024. The timeline assembled itself with forensic precision. They had evicted me November 25th, 15 days after the IRS lien was recorded, 3 weeks after the certified notice they had intercepted. The kitchen intervention with the forged document had not been a spontaneous family crisis. It had been a designed operation, and I had been the target because I was the most reliable funding source available to people who needed immediate cash to prevent the federal government from seizing their primary asset. Buried in the notice's 3rd paragraph was a sentence I read 4 times. Affected parties with documented financial interest in the lioned property may request a collection due process hearing within 30 days. At 3 in the morning, surrounded by coffee cups and legal research websites, the understanding settled into place with the solid, irreversible feeling of something that will not unsettle again. I was not simply a daughter who had been exploited. I was a creditor with documented financial contributions to a piece of real estate, and I had legal standing to recover them through federal processes. The deadline for filing was December 10th. 18 days. Enough time if I moved immediately. The first attorney I consulted, James Hartley of Hartley & Associates, reviewed my documentation with unconcealed skepticism. Courts assume family contributions are gifts, he explained. Without explicit written agreements establishing an investment relationship, my parents would simply argue I lived rent-free and contributed voluntarily. His recommendation was family mediation. I paid $400 for that advice and left feeling the hollow quality of someone told the system has no place for the kind of harm done to them. Then, on Wednesday evening, Sandra Webb, a CPA conducting a routine audit for another client, called with something she had discovered in Fairfax County property records. Double tax payments from 2021 through 2024, traceable to my account, and more importantly, a deed amendment filed October 28, 2024, adding Tyler Brooks as joint owner. October 28, 13 days before the IRS lien was recorded, Tyler had been placed on the deed as a protective measure against federal tax seizure, while I was still depositing money into the household he had just quietly taken partial ownership of. Under the Uniform Voidable Transactions Act, she told me, continuing to accept financial contributions after secretly transferring partial ownership without disclosure constitutes fraudulent concealment. I built a litigation strategy in 3 phases between midnight and 4 in the morning. Phase 1, emergency protection, including a temporary restraining order and a lis pendens to cloud the title. Phase 2, subpoenas for complete bank records and certified deed history. Phase 3, claims for unjust enrichment, fraudulent transfer, and constructive trust over the property improvements I had funded. Nicole Torres of Torres & Associates reviewed my folders for 14 minutes and said, "This presents textbook unjust enrichment complicated by fraudulent timing. Your documentation is unusually comprehensive for a family dispute case." The retainer was $12,000. She filed the emergency TRO petition that afternoon. I slept for the first time in 3 days. Friday at 5, Nicole called. My parents had a closing scheduled for Monday morning at 9. Cash buyer, no contingencies, a company called Fairfax Investment Properties LLC. Sale proceeds. Approximately $400,000 after satisfying the IRS lien and mortgage. Once that money dispersed, every legal remedy I had built would become nearly impossible to pursue. 72 hours to stop it. File everything tonight, I said. She already was. Monday at 8 in the morning, Fairfax County Circuit Court, case number 2024-8847. The courtroom smelled of old wood and nervous human beings. My family sat across the aisle looking like people who had planned something precise and watched it become something else entirely. My mother held my father's hand. Megan held Lily, who babbled cheerfully, completely unaware of the significance of the large, important room she was sitting in. Nicole laid out the sequence cleanly. Deed amendment, October 28th. IRS lien recorded November 10th. Eviction served November 25th. Property sale scheduled December 2nd. The opposing attorney offered the standard response. Family contributions are presumptively gifts, no written investment agreement. And Judge Patricia Whitman interrupted him mid-sentence. The timing of the deed transfer raises significant fraudulent conveyance concerns, she said. This appears to be a calculated effort to shield assets from federal collection while continuing to receive financial support from the contributing party. Nicole then presented the email thread between Tyler and Atlantic Coast Title Company. Subject line, urgent, 1247 Maple Street closing, moved to Monday, discussing the need for an immediate cash closing before IRS complications. The email was 11 days old. The sale had been arranged while my family knew legal action was being prepared. My mother began crying, not performed emotion, but genuine unguarded tears from someone watching a situation they thought they controlled become something they could not stop. Megan whispered urgently to Tyler, "What did you do?" He had no answer the courtroom could hear. Judge Whitman granted the temporary restraining order, blocking the 9 a.m. sale effective immediately. The gavel came down with a sound that was both bureaucratic and final in the way that only legally binding things can manage. Outside on the cold December sidewalk, Nicole presented the options. Option 1, Tyler transfers his fraudulently obtained deed interest back. The family signs a secured promissory note for $67,000 at 6% annual interest. Over 36 months, the forged loan document is voided, and no criminal charges are filed for the forgery. Option 2, full litigation under the Virginia Uniform Voidable Transactions Act, 12 to 18 months, with financial exposure Nicole estimated at $200,000 or more. My mother looked at me across 3 feet of courthouse sidewalk and said, "Jessica, do you want to destroy your family?" It was the wrong question. The question was not what I wanted to do to them. The question was what they had already done to me, and whether I was going to let it define the next 5 years the way it had defined the last 5. I took option 1, not because they deserved it, not because what they did was forgivable in the way the word forgiveness usually implies, but because I had spent 5 years being the person in that family who believed that completing the thing you started matters. Who kept every receipt in a labeled folder? Who drove to the hospital billing office in person? Who put $1,900 on a credit card so a child too young to understand would have photographs worth looking at later? I was done funding a version of myself I did not recognize. The promissory note was signed on December 14th. The lis pendens was released. The property stayed in the family. $67,000 would come back to me in 36 monthly installments, and I would deposit each one into an account that existed only in my name, at a bank my family had never heard of, with statements going to an address they would never have. Some things, once you've documented them completely, you can let go of. Not forgive, let go of. There is a difference. And I had learned it in a motel room at 3 in the morning, with coffee going cold and the law laid out in front of me like a map of somewhere I had never intended to go.